eti unim se Kelvin Taylor eba bedu Ghana osako Supreme Court oko wini ye no aye conversation bebre between Crawford bebre ebisi say the Supreme Court pa na ode nanim onyama to fom say na moamu nua na obi edi na tem na so ono ya ade am support no enti moamu tumi no na mo de ba fom na no na bi so say na no sa ka na pon so didi judge fo atem no ankosi hwenti Kelvin so didi atem a enye hwe na se minia obe break say ade se Kelvin Taylor abaga na ha no Paul Adom Otchere na Otchere mu say Kelvin Taylor ba wa ba ha no ehuma Ghana de enti a ehuma Ghana no say Kelvin Taylor edi nkrofo atem eti Paul Adom Otchere said that ye video a ode kire atem didi ni nipa titiri wa Ghana Kelvin Taylor edi wo mo atem yengo hwe say video ni mra
so abonya will come and say na can you Japan scandalized court or more man is right Kelvin Taylor scandalized and I made them scandalized them man is right and then the confusion will start. A court will say they won't give certiorari. MPP will put people on the streets. Police will shoot at them. And then we are turning it upside down.
Hell, do you think you are? Foolishness. We pay you. Massa, I don't want any foolish idiot to text me later. Who the hell is Sam Dodge? I say, who the hell is that fool? I'm ready for you any day. Foolish man. Ube who say, a drop you, baby. Me say, remember we drag at them. Me say, ube wrong what's not from. Me, I'm telling you that. If somebody thinks I'm sitting here because of Mahama, then you are stupidly stupid. I'm telling you. You can call your Mahama and ask him. And if John Mahama thinks I'm sitting here because of him, he is thinking stupidly. Oh, me shebia honte. Akonya bia to say toilet. Oh, you hine se bedi enim na musomra so say you se be cancer man puntumra abrabom. Edian hine na yedi ni sa no. Ah? Edian hine na yedi ni sa no. Wo na wo ma santemai say otufo. Wo na wo say santemai o tom. Obi o mon kan kire wo. Asantemai say e ye wo otufo na otufo te wo. Na yesi sebio wona nanom mo baaye no sa nkwase asem we komo so ankenda akonwa kase we enkeda ho moto so nsemfo so dodo ye bu akonwa nim tia na yesoso nyoma so otufo you have limited power. Asante is nothing. See 2 million asante biem 2 million ni menhia biem Nimumpaya wo wiase nyina ye showa masarai bebediza when the Corinthians onimdie wo nyina ontumi san ba yare Ankan Williams ono so ne ba no so aboda mo se den osoro na wate chain we ni kwate fia te se mire edidi nkwase asem o TikTok was Ankan William wa bompaya wo wiase nyina de brofo abo ontumi san ba yare na mo mogibigimi ara mensa otabo akwatena court a bank board so we wie sika tetram o de nam Ghana osoro na hye Igbo curtains Reverend Obofo se hwanwan ne nine say Egyptian pen o de nkwase afọ budi de chi wagigi mu sika nyina koto phantom and o ka kire mu se osom no eya azan afa oba no fon chen mi and why kese chen mi I said if Somalia ekuro bi ade fe no enkinkensu and ade ne baaye and otowa hwa na fo no some wagimi arimi yawe edidi chief imam office de chi and oye corruption edwuma ho because odum say chief imam enyini chief imam on TV chief imam on tie radio and arimi yawe na bodwe se peg
and no na hunu ni wo ho no enti nra asem no ba na wie ye no ya ade se ke Paul Adom Otchere onso ono ni Kelvin Taylor wo mu beef dado enti we ba beto mu no aye te say the Kelvin Taylor wo upper hand no and Paul Adom Otchere say memory act to it na ade enti Paul Adom Otchere so abekire na adwen e de afa nsem ne ho me mpese me ye asem ne tentente yenkotie Paul Adom Otchere ne nsem a ode ba beto dwa.
We just want to say this from the constitutional arrangement and from democracy, that this is the Chamber of Parliament and this is the office of the executive. There's a reason why, under most democracies, including Ghana's democracy, people are called upon to elect by voting the people who end up in parliament, in the legislature. People are called upon to elect by voting the man or woman who will end up as the top executive, the president. They are called upon to elect. There's a reason why we are not called upon to elect the judiciary under our democracy. In some places it happens, but in most places it doesn't. We are not called upon to elect the judiciary because the longest lasting democracies have observed that there always need to be one state institution, an arm of government, that is the bulwark of democracy. So under the Constitution, when this one expires on 6th January, and this one also expires on 6th January, it is this one that does not expire. So on the morning of the swearing in, the morning after Parliament has been dissolved, before the new Parliament comes in, the Lord Chief Justice, acting as the fourth most important person in the pecking order, maintains the position of the leader of the state. And then the Chief Justice goes to the Independence Square. Now, the reason is that there has to be some even playing field for all Ghanaians here. Everyone understands, since Marbury and Madison, that the Supreme Court, when it's making a decision, can make a decision based on political philosophy. If you go to America, it's not a secret. They'll tell you that the Republicans have the court or the Democrats have the court. Not because the Democrats elected people to the courts, but because the Supreme Court judges, of 9 of them, are divided into, people know how they think. In America, because of data, by the time you become a Supreme Court, they know that you are right, left, center. Everyone knows that. So if the court is more right-wing thinkers, then on matters that go to Supreme Court on policy, on constitutionalism, they are more likely to go left or right. On every matter of policy and constitutionalism, there's always a left and right. You take free SHS to a court that you want to say that free SHS is illegal. You will notice that the right-wing people might support you because they don't like government participating in all of those things. You will notice that the left-wing people will not support you. They will agree that it's not illegal, government must pay for it. On a matter like that, on a policy like that, everyone knows that there will be left and there will be right. 31st December to be celebrated as a holiday. There will be left and there will be right. Election petition has come. The fact shows a certain way. Those judges who are in there for the stability of the state will tell themselves that the president has already been sworn in. He has formed his government. He's 9 months into the government. Why are you going to give a ruling that we should go back and vote again? No. I'm going to be progressive. I go on. Then there's another judge who is a stickler for truth. That's their philosophy. That even if he's in power for 2 years, if the election was wrong, it's wrong. Analysts can look at the Supreme Court of 11, 10, 9 and say that this case is going this way. That's allowed. That's really allowed. But if you come below that and you come to procedure and processes, it is not permissible that processes can change because the politics of the executive or the politics of the legislature is dictating what happens here in high courts, in court of appeal. So if somebody has defamed me, or I have defamed somebody, I've sat here and said that Omanebo Ama is this, that. Omanebo Ama sues me. And then he sues me in defamation. Come and prove what you said. And it should be thought that within the context of politics, the High Court judge would determine that MPP is in power, so he'll rule for me, or that NDC is in power, so he'll rule for Omanebo Ama. That should never be the case. And that has happened in Ghana recently, and I'm going to show you how it happened. The other point I'll make before I show you what had happened is that the framers of the Constitution are also aware, and I'm coming to the constitutional article, or perhaps, no, let me do the Ken Crunchy one first. Now, this is Ken Crunchy. During the election petition of 2013, he made statements that were suggested that he had scandalized the court. Ken Crunchy MDC was in power during the election so this is 2014 matter. Or 2013, during the petition, yes, NDC were in power. So Ken Crunchy was said to have made statements that are scandalous of the courts. So they hauled him before the court. His lawyer was the Adom Otchere. The court made the decision that Ken Crunchy has scandalized the court, and therefore he should serve a contempt of 1 month. He was NPP. He's still NPP. NDC was in power. He was NPP. During the pendency of the trial, Akogun, Mugabe Mase, and the other guy, they also made statements that were scandalous of the court. What happened? Guess what? They were also hauled before the court, and they were convicted for contempt. Keep the 3 there. I'll come to Enieboa. Because in the context of procedure and the context of the courts, there should be no favoritism as to how the court relates to this and relates to that. NDC was in power. And the 3 of them were convicted by the Supreme Court. John Mahama was president. And then they went into prison. But here's the catch again. Because the executive president, elected by a popular majority, is an important factor in the constitutional arrangement, every constitution gives the president the power to pardon people. Do you know why it does that? Because the constitutional framers fathom that the president's brother, the president's mother, the president's friends, his classmates, the relative of his cabinet, they may fall foul of the law. And if they do, a democratic arrangement does not permit the president to save them so long as they've fallen foul of the law. So if the president's brother drives a car into 30 girls and kills them, the Constitution knows that the president, even though he's president, will not be able to do anything about it because his brother will be treated by the law as it ought to be under a democracy. However, the constitutional framers don't want the presidents to be in a bad frame of mind. And whether, because you are human, whether you like it or not, if the president's brother is jailed, he will be in a bad state of mind. If the president's in a bad state of mind, it's probably bad for the whole of Ghana. If the president is not married and he has a girlfriend, and his girlfriend goes to slap somebody at a supermarket, that girlfriend of the president will be hauled before the law. And the constitutional framers are aware that this will disturb the president. However, we do not want the president to be able to interfere with it because equality before the law is a bulwark of constitutional democracy. Therefore, in almost every constitution, the president is allowed to take some people out of jail.
Eti Paul Adom Otchere na who say ordene de aba betu dwa no. Na obewie kura no no sa frɛ lawyer baako, lawyer Sophie intim owo asen ehonom no ono ntim fojo ono nso say wona wo ye lawyer ni ka asemi bi ne enko enti MP intim ono nso intim fojo enso kan na asem.
So you were in court this morning, very briefly. What happened?
So the court ruled. So initially, when the party, that is Kevin Taylor and his lawyer, the Leonard Peter Okujeto, were in court, the Attorney General's department did not appear. No, the picture of the Supreme Court, please.
Yeah, that's the Supreme Court. He wants the Supreme Court building. Okay.
So the lawyer, the states, the Attorney General's department, no representative came from the Attorney General's department. In fact, Justice...
No one.
That is so. I mean, there were lawyers from the Attorney General's department for other matters, but not specifically for this one.
So the Attorney General was not represented?
Yes. And indeed, I remember Justice Amadou Tanko insisted and said that everybody must see that indeed the Attorney General's department was saved and they did not appear. Indeed.
They did not appear?
Yes, there was no representative.
But they can do that? It's easy to do
well, you may, but it would be best to
but
at least appear and tell the court, exactly,
yeah.
appear and tell the court that we have no interests opposing the motion, but not to appear. But maybe somebody was also assigned, maybe the person could not make it, and so we cannot really jump the gun and make conclusions. It would be quite unfair to them. And so the decision was handed down, and we do not have the full complement of the judgment of the ruling yet in respect of this matter. But it would seem that the main arguments the court was making was that the procedure is that the courts must first make what we call a summons. The summons, as we discussed earlier, the summons is directed at the person to attend court and show why he should not be placed in custody. The arguments that actually erupted after, and in fact before, which we discussed here earlier, was that the summons operates in this instance also as an arrest warrant, in the sense that the arrest warrant is to show cause why he should not be committed.
So when such a person is arrested, he's not being taken to jail. He's being taken to
brought
court.
To court to show why he should
to the same court that did the warrant.
Exactly, why he should not be thrown behind bars.
And he can make arguments.
Yes, he can make arguments. So he can beg. He can make a constitutional argument. In fact, I even believe that, that's my opinion, Kevin Taylor should have gone before Chamber and
to withdraw.
Not withdraw, but even make the argument that the power of contempt, the ambit of the power of contempt, there should be an interpretative, the Supreme Court should have interpretative guidelines for the exercise of the power of contempt.
That is too broad.
It's too broad, it's too vague. So that there could be some jurisprudential discussion, and then upon that we go to the Supreme Court for a determination. But we have missed out on that opportunity because. But
maybe he was worried that if he appears before Chamber 4 will say, "I don't agree with you. Go to jail."
Well, that is one way to look at it. Everybody.
But
must
somebody was telling me that the other way
to
have gone about it was that I bring him before Chamber 4. Whilst he's standing there, his lawyer informs Chamber 4 that the certiorari application has been filed at the Supreme Court against you. Can you stay and let's hear the certiorari application?
That's
and then the application is granted, and so Chamber 4 knows that That would have been, I mean, they use certain words.
The purpose of so the thing is that the arrest warrant is directed at law enforcement agencies to procure someone's attendance. And so the arrest warrant in and of itself is not a process or a procedure that goes on in courts. It is directed at the police. It's more or less an order of the police.
To go and bring this guy to the court.
Exactly.
Yeah.
A summons is directed at an individual to appear. Unlike the arrest warrant that is directed at the police
to go and get him.
To procure the
But
attendance.
arrest warrants can also locate a person hearing about it, show up.
Oh yes.
Okay.
If you hear there's an arrest warrant,
so if it is true that there were agencies of state who protected him away from the court, will they have committed an offense in the light of a certiorari having been issued later?
I mean, at the time it was issued, and
that they found him.
Yes, so the legal principle, if you and I litigate over land, and the court gives you judgments, and the court says that you are the winner, and therefore the land is yours, I cannot say because I disagree, I am not complying with the order of the court. Till that order is set aside, it is the law, and it is what's supposed to stand.
So those persons may, if it's true that happened, they may have questions to answer.
Exactly, but the thing is that it is the state that ensures these things are follow through. But it seems the state also did not appear in this instance for whatever reason. So we are waiting for the full reasons of the courts in respect of this issue to make a full and comprehensive analysis as to why the courts ruled in this manner. But I'm sure it's an issue of maybe a view of technicality against intent or whatever. I don't think maybe the courts would have.
There's a matter that I have to bring to your attention. It's been on most of the NDC platforms. They said that Kennedy Japan, there's another article that says Kennedy Japan's own was completely different. Kennedy Japan scandalized the court by attacking a judge. A judge issued a warrant. He went to the Supreme Court on the basis that the judge did not ask him to come and defend himself. The position of Kennedy Japan's lawyers was that Kennedy Japan is a member of parliament, and you know where to find him. So the judge should have issued it on Parliament that produced Kennedy Japan, and they would have done so. But to go ahead without hearing him and do that, and that's the decision the Supreme Court took. So they are thinking that it's on all fours, as the lawyers say, with this one, and there's a lot of disagreement on social media.
The issue of
that in this one, there was no way to serve him. He was not going to be willing to come. So it's clearly different if you issue the arrest warrant. You know.
The issue of service, particularly for MPs, is that there is a specific way MPs are served. So for me, if somebody wants to sue me, the person can meet me, can come to my office at Adabraka and give me a sue wherever. I'll come here on my way home. But MPs, it's different. There are days they are supposed to be served. In fact, in Parliament, there are officers that can receive processes from the courts on behalf of MPs. And the rationale is that the job of Parliament is very fundamental. We were all in this country when the D levy was passed at 11:30, 12 a.m. And so the nature of Parliament is it is standing for the 4 years. There are times here.
So every minute he's in Parliament.
Every minute
he's deemed to be doing parliamentary work.
Exactly going to or from. Even the act of parliamentarians going from place to place, talking to.
It's all deemed to be part of
parliamentary work. Parliamentary work is not just sitting in the chamber and saying yeah. And so the rationale behind that can be said that there is a format, and we all know the position of the law in the NTHC case, that when the law lays down a specific process for doing something, it is that process that ought to be followed. In this instance, Kelvin Taylor is not an MP. There is no specific instance for procuring his attendance. There's no specific process for procuring his attendance. In any case, the other side may also argue that in any case, it is still the same thing, that the summons must have been issued, and then upon him failing to attend courts, the arrest warrants, because the issuance of the arrest warrant also puts some, makes him a sort of pariah. People begin to say, hey, now you arrest warrants, well, so now there's an arrest warrant on you, and so the court should have afforded him the opportunity to attend, and then upon failing to attend, then he would, the courts could.
So those who now want to sue Kelvin Taylor, and those who have sued him already and obtained judgment, is it good news for them? Is it better news for them than that he's not available?
It's not. Well, he has to be saved. He has to be saved. And if his location in Ghana cannot be found, they can attempt service 3 times. If they attempt service 3 times, they can apply for what we call substituted service, where he can be served through WhatsApp, he can be served Facebook, posting notice on the walls of the high courts, the notice.
So he pays Facebook and tag him.
Yeah, you can post on Facebook and tag him.
And then the trial can start.
Exactly.
It will be assumed that he doesn't want to participate.
Exactly.
Then you go and get a judgment.
And then can get
then whenever
judgment.
you can enforce it against him.
Exactly. You do what we call entry of judgment, where you detail the amount of money that has to be collected from him. And then you also attempt service of the entry of judgment. If still the process, you do it 3 times, you come for substituted service, it is posted, and then it can be enforced. However, if he is not in the jurisdiction, that is also there's a different procedure for instituting actions against people that are not in the jurisdiction.
But given that he's not ordinarily resident here, he may not change that. Is he now to be considered as in the jurisdiction or not?
Yeah, he's a Ghanaian citizen, and he lives. Well, I won't say he lives here, but
he has been here to seek legal process,
exactly,
legal redress.
Yes, and he attended. In fact, if those who were going after him may have suspected he would have been at the Supreme Court, they could have been hiding at the premises. So immediately he came out.
I think you heard the conversation between me and another lawyer who said that he just got there and then the Prado took off and he taken the number of the Prado and he's doing some.
He should have sat on an Okada and chased the Prado.
He said he just got there and the Prado took off. He was just going to get the bailiffs to arrest the Prado that he was using so that national security will beat them up and then we can have a story.
Maybe the lawyer is a gentleman. Someone would have sat on an Okada and chased the Prado because once he leaves the court premises, how are you going to find him again? And in our jurisprudence, service is so fundamental.
Yeah.
If you have not served a process on a party, the courts can say, I do not have jurisdiction to.
But here you can do substituted service.
Exactly. That's it. So, and even the substituted service, there's a threshold. You have to attempt service 3 times.
At least
and
3
show
times.
the court at least 3 times.
So that you are unable to reach him.
I'm unable to reach him. And any future attempt would
be
not
futile,
Exactly. And then the court would give
because he would have left Prestige Link and gone back to America or gone to
I don't know if it's at #1 Prestige Link, but that is what is in there.
I hear they are doing party. They are doing party today.
Oh,
thank you very much.
You are victorious. You have to celebrate.
Thank you.
My life is in stage.
Ne deɛ na ɔde aba abɛto dwa no asɛm wei deɛ sɛ Kelvin Taylor wo kurom ha deɛ wo ne ho akɔka bi me kama no atom me mpa ase bia aha yɛ info I o number 1 super duper o skin lakuta macro